So, report of police officer. Every investigation under this chapter shall be completed without unnecessary delay. And as soon as it is completed, the officer in charge of police station shall thereof, the public prosecutor, forward to a magistrate empowered to take cognizance of offences in police report, a report in the form of prescribed by the provincial government setting for the names of the parties, the nature of the information and the names of the person who appear to be acquainted with the circumstance of the case and stating whether the accused of arrested has been forwarded in custody has been released on his bond, if so whether with or without sureties. Communicate in such a manner as may be prescribed by the provincial government the action taken by him, the person, any by whom the information relating to the commissions of the offences was first given. Provided that where investigation is not completed within the period of 14 days from the date of recording of the first information report, under section 154, the officer in charge of police station shall within 3 days of the expiration of such a period forward to the magistrate through the public prosecutor an interim report in the form of the prescribed by provincial government, stating therein the result of the investigation made until then, and the court shall commence the trial on the basis of such interim report, unless for reason to be recorded the court decide that the trial should not be so commenced. Where a superior officer of police has been appointed under section 151, the report shall in any case in which the provincial government by general or special order so direct be submitted through that officer, and he may be pending the orders of the magistrate direct the officer in charge of police station to make a further investigation. Whenever it appears from the report forward under this section that accused has been released on his bond, the magistrate shall make such order for the discharge of such a bond, otherwise as he thinks fit. A copy of any report forward under this section shall on the application be furnished to the accused before the commencement of the inquiry or trial, provided that the same shall be paid for unless the magistrate for some special reason thinks fit to furnish it free of cost. Where the officer in charge of police station forward a report under subsection 1, he shall along with the report produce the witness in the case except the public servant. The magistrate shall bind such a witness by appearance before him or some other court on the date fixed for the trial. Police to inquire on suicide. The officer in charge of police station or some other police officer especially empowered by the provincial government in that behalf on receiving information that a person has committed suicide, has been killed by another, by an animal, by machinery, or by an accident, has died under circumstances raising a reasonable suspicion that some other person has committed an offence, shall immediately give information thereof to the nearest magistrate empowered to hold inquest and unless otherwise directed by any rule prescribed by the provincial government, shall proceed to the place where the body of such a deceased person is, and there in the presence of 2 or more respectable inhabitants of the neighborhood shall make an investigation, draw up the report of the apparent cause of death, describing such wounds, fractures, bruises and other marks injury as may be found on the body, and stating in what manner or by what weapons and instrument any such marks appear to have been inflicted. The report shall be signed by such a police officer and other person by so many of them as concurs therein, and shall be forward to the concerned magistrate. When there is any doubt regarding the cause of death or when for any other person to the police officer consider it expedient so to do, and he shall subject to such a rules as the provincial government prescribe this forward the body with a view to it is being examined to the nearest civil surgeon other qualified medical men appointed in this behalf by the provincial government, if the state of the weather and the distance admit of its being so forward without risk of such a putrefaction on the road as would render such a examination useless. Omitted by so not made, the magistrate of the first class are empowered to hold the inquest. Grievous 174 grievous injury by burns, where a person grievously injured by burns through a fire or kerosene oil, acid, chemical, or by any other way is brought to medical officer on duty designated by the provincial government. For his purpose, such incident is reported to the officer in charge of police station, such as medical officer duty is the case. Maybe officer in charge of police station shall immediately give an intimation throughout the nearest magistrate. Similarly, the medical officer on duty shall record the statement of injured person immediately and arrival so as to ascertain the circumstance and cause of the burns injuries. The statement shall also be recorded by the magistrate in case the injured person is still in the position to make the statement. The medical officer on duty, as the case may be, the magistrate before recording the statement under subsection 1 shall satisfy himself that injured person is not under any threat or duress. The statement so recorded that shall be forwarded to the session judge and also to the district superintendent of police and the officer in charge of the police station for such action as may be necessary under this code. If the injured person is unable for any reason to make the statement before the magistrate, his statement recorded by the medical officer duty under the subsection shall be sent to seal or convert to the magistrate the trial court if it is other than the magistrate and may be accepted in evidence as dying declaration. Injured person expired. Power to summon the person. A police officer proceeding under section 74 may by order in writing summon 2 or more persons as the aforesaid for the purpose of the said investigation, and any other person who appears to be acquainted with the facts of the case. Every person so someone shall be bound to attend and to answer truly all questions other than question, answer to which would have a tendency to express to a criminal charge or to a penalty or forfeitures. If the facts don't disclose cognizable offences to which the section is applies, such a person shall not be required by the police officer to attend a magistrate court. 104 inquiry by magistrate into cause of death. So when any person dies while in the custody of the police, the nearest magistrate empowered to hold an inquest shall, and in any other cases mentioned section 74 classes A, B and C of subsection, any magistrate so empowered may hold an inquiry into the cause of death and either instead of or in addition to the investigation held by police, and if he does so, he shall have all the powers in conducting it which he would have in holding inquiry into an offence. The magistrate holding such an inquiry shall record the evidence taken by him in connection therewith in any of the manner therefore according to the circumstance case. Power to disenter corpus. So whenever such a magistrate considers it expedient to make an examination of the dead body of any person who has been already interred in order to discover the cause of his death, the magistrate may cause the body to be disinterred and examined.